Hello, everyone, and good afternoon. Welcome to the Changing Profile of Whistleblowers in False Claims Act, or FCA, litigation. I'm Jody Rudman. I'm joined by Jonathan Porter. We'll introduce ourselves in just a moment, but before we do that, let me just cover with you a few housekeeping items. At the bottom of your audience console, there should be some application icons that you can use during the program today. If you have any questions, feel free to submit via the question box. We'll try to answer questions as they come in and as time permits, but if your question needs a more fulsome answer or we just kind of run out of time, then we'll be happy to answer your questions later in email. You should have access to a PDF of today's presentation in the program materials folder. There are auto-generated closed captions available to you. If you want to turn those on, you can click the CC button on the bottom right corner of the media player box. This program is approved for legal education hours. So for live attendees, you can report your hours by clicking on the CEU icon at the bottom of your screen. There will be a certificate of attendance, including course numbers, that will be emailed to you tomorrow, along with a recording of today's webcast for you to watch and share if you're so inclined. Toward the end of the program, if you feel like completing that, it will be short, won't take much time, but we will use your feedback to plan any future programs applicable to your business needs. So that's all for housekeeping. We'll go ahead and get started with our program. As I mentioned, I'm Jody Rudman. I'm in Husch Blackwell's Austin, Texas office. I am the practice group leader of the firm's white collar and government investigations practice group, and I am the chair of the firm's False Claims Act working group. And as I mentioned, I'm very happy to be joined by Jonathan Porter. And Jonathan, I'll let you introduce yourself.
Thanks, Jody. Yeah, I'm Jonathan Porter. I'm a partner at Husch Blackwell. I'm located in Savannah, Georgia. Happy to be here. I'm a former federal prosecutor. I handled some False Claims Act cases within the Justice Department and helped Jody with our clients' various government investigations and False Claims Act needs, and host a podcast that you guys may want to check out. It's the False Claims Act Insights podcast, which Jody was our first podcast guest way back months ago. So that's been fun to do. But Jody, I'm excited that we get to talk a little bit more in depth about whistleblowers in this webinar.
I am as well. And there is a poll question that's up on your screen now. Some states, in order to get CLE credit, do require this type of poll. So if you guys don't mind responding to the poll question, that would be great. It's an easy one. Do you have any experience with responding to a government investigation of any type? And we're not going to call on you or require you to provide any answers, but if you want to go ahead and answer, that would be great. While you do that, let me give you a little overview about what Jonathan and I are going to be talking to you about in the next hour or so. Our goal today is obviously to talk to you about whistleblowers and where do they come from and kind of what does the profile of a whistleblower look like in 2024. We're going to get to that by talking to you about what you might think traditionally whistleblowers consist of, and then, kind of what we're seeing now and areas of heavy whistleblower activity. We'll move from there into talking about constraints on whistleblowers, opportunities to sort of cabin maybe the perceived abuse of the False Claims Act system, areas that are available to kind of keep too much whistleblower activity in check. We'll move from there into mechanics. How does this process work? Why does the DOJ seem to encourage whistleblower-driven False Claims Act litigation? And then we're going to kind of talk about practical considerations and then move into a general overview of litigating and settling and kind of what the process looks like. Although today is certainly not legal advice of any kind, I do want to reiterate that we're really focused in large part on talking about the False Claims Act as a function of federal law, to the extent that there are individual state False Claims Act laws and individual nuances. Of course, it's always important to make sure that you're very aware of the individual law that may be at issue in any particular investigation or litigation. So from that, let's just talk quickly about nomenclature, and then we'll kick off the substance. We're calling it whistleblowers throughout our time together today. In False Claims Act litigation, when a whistleblower files a False Claims Act lawsuit, often we change that nomenclature and the person is a relator. And we'll use whistleblowers, but if you thought of them as relators because of litigation, you would not be wrong. You will see the names of cases in relator-driven False Claims Act litigation is, for example, the United States ex rel, which means that there was a relator present. And many False Claims Act, all False Claims Act relator-driven lawsuits have a Latin term for them, which is pronounced differently in different parts of the country. Down here, we call them quitam lawsuits. It's Q-U-I-T-A-M, and you may have heard them pronounced, or perhaps you pronounce them as quitam, quitam, quitam. Pick your pronunciation. We'll call them quitam to the extent we talk about them in that way. So moving on, where do whistleblowers in FCA or False Claims Act cases come from? Well, traditionally, you might expect many False Claims Act whistleblowers to be current or former employees of the entity that is being sued. And that is indeed the kind of traditional avenue for False Claims Act litigation. But the statute contains no constraint that False Claims Act relators come from the ranks of current or former employees. So what we're seeing more and more is False Claims Act litigation that's driven by a whole other cadre of relators or whistleblowers. And these include competitors, compliance consultants, auditors in the healthcare space, patients. Jonathan, I know that you have kept your ear to the ground on a lot of current False Claims Act litigation. What else are you seeing in this space now?
Yeah, so one of the biggest, one of the most interesting parts of this is that there are companies that are getting really, really good at doing data analysis. A friend of mine who's a very experienced relators attorney had a really nice settlement earlier this year for a client that mined data to find PPP loan fraud. And that ended up being a really good case. I think it was meritorious because the Justice Department intervened and settled the case. So I think you're going to see a lot more of the data mining, which is really, really interesting. I don't know how effective that's going to be outside of the PPP space where there's publicly available stuff. You can get a bunch of healthcare data that's de-identified, but I don't know all that much that you could do with it. But the big thing to know about whistleblowers and where they come from is DOJ really is vetting whistleblowers to see what type of a witness they would be, whether that's someone that they want to sort of exist on the same side of the V with. And so you do see patients that are good relators, current employees, former employees who left on decent terms, very, very good, trustworthy relators, because they could speak to what the organization was thinking at the time it was making these claims, because that's a critical part of the False Claims Act is what knowledge was there. And so but you do see competitors. You see competitors and customers. I even saw a government employee file a quitam when I was at DOJ. I thought that was interesting. And so they really do. They come from all walks of life. That last that last rectangle that we have on the screen there, anyone with knowledge of false claims of the government, that's an important, rectangle, because that is who can file a false claim, and it's not limited. And by the way, Jody, I say whistleblower instead of relator because I'm tired of my phone autocorrecting relator to realtor. So that's the real reason that I like whistleblower.
Fair point. Fair point. Jonathan, where do we see a lot of heavy whistleblower FCA activity, especially in this day and age? I think the traditional province of FCA work, expected would be the healthcare space, which is, we could have a whole presentation on FCA cases in the healthcare space altogether. But certainly I think that's traditional, and of course DoD contracting. But what else are you seeing nowadays in heavy activity in this space?
Yeah, I think every year the DOJ releases their False Claims Act report, you see that healthcare is well over half of their recoveries, well over half of their new cases. The last I heard, healthcare is about 20% of our nation's economy. And so, and the government pays a good bit of that through Medicare and Medicaid and TRICARE. That's not even getting into, Part C programs. So there's all the government, because the government pays for so much in healthcare. Healthcare is always going to be a mainstay of whistleblower FCA activity, especially because, when you're talking about the False Claims Act, you've got to show that that these are knowing false claims. And so there's a big difference between a company just doing something wrong, a healthcare provider just doing something wrong, and a healthcare provider knowing that they've done something wrong. And so whistleblowers play a large role in proving up that, hey, this isn't just we did something wrong. This is we did something wrong and we knew we did something wrong. And so whistleblowers have that ability in the healthcare space. Currently, the leadership of the Department of Justice continues to say that the big emphasis is COVID-19 relief fraud. A lot of those cases are criminal, but I think the people who are looking at these issues from a high level are realizing they're not going to get to all of that. I did a bunch of those cases when I was at DOJ on the criminal side. They're not getting to, even a small fraction of, they're getting to a small fraction. They're not getting to a meaningful portion of PPP fraud. So I think you're going to see a little bit more movement on the False Claims Act space. What's interesting, there's a district, the Northern District of Mississippi, has filed hundreds of False Claims Act complaints against people who got PPP loans that they think shouldn't. And the vast majority of those are being resolved in the form of judgments because the people who got these PPP loans are just not showing up to contest this. They're not going to go into court and subject themselves to, making statements that they can get in trouble for. So I'm curious if you're going to see a little bit more of that as different U.S. attorneys' offices realize they've got to get these cases moving, and they're not going to have enough time to criminally prosecute all of those cases. The other thing I think you're going to see, Jody you mentioned DOD. You're going to see a lot more. I think you're going to see a lot more on the grant fraud side. The government pays a ton of money every year to support research, and I think you're going to see. We've seen some big cases in the last 4, 5, 6 years. I have a feeling you'll see even more. And so that's going to continue to be a big area. And then COVID lab testing, that's another one where there was a lot of, for those of us who were in DOJ when COVID was going on, we know that was a program that saw some pretty large bills pretty quickly. And so I think you'll see more enforcement on that in that space as well.
Yeah, I think we're going to see post-pandemic activity in this space for a long time until that finally unwinds. And that pertains, of course, to pandemic relief programs and the funding for those programs, as you mentioned, PPP loans in particular. And then, of course, the lab testing, I think, will take a while to unwind itself. But undergirding all of that, I think we're going to continue to see FCA activity in sort of writ large in the healthcare space and in the DoD space. And as you mentioned, in the research grant space, kicking up and ongoing for, well, a long time. So you might be asking yourself, how do we know that there are guardrails or cabins or restraints on whistleblowers just sort of coming forward and making assertions or allegations that, you know, perhaps might be spurious or unproven or ill-founded? Well, there are protections, and some of them are on the slide that's in front of you now, and they include, of course, you know, the rules of civil procedure, and then they include opportunities for defendants to move to dismiss or otherwise convince the government to move to dismiss in cases that don't surpass certain criteria. So, for example, Federal Rule of Civil Procedure 9b is a pleading standard, and it requires in allegations of fraud that any plaintiff, and that includes a False Claims Act relator, has to plead fraud with a certain level of particularity. And many cases are dismissed alleging fraud at the motion to dismiss stage because the plaintiff hasn't and can't plead fraud with the requisite particularity for the case to even really survive enough to move into full-on litigation. There's also the scienter requirement, or the state of mind. And Jonathan, you alluded to that a moment ago, but a False Claims Act case is not merely premised on somebody filing a false claim, you know, with the government or not providing to the government money that was due. But that has to be done with a certain level of knowledge, a certain state of mind, or scienter. And there has been some recent litigation over that was resolved by the U.S. Supreme Court, and I think that's going to provide some more avenues for litigating the knowledge component of any False Claims Act case. But this is an essential element of pleading and surviving the pleading of, and ultimately proof of, a False Claims Act case. Then, of course, at the procedural level, we have the public disclosure bar. So a False Claims Act case is not well pled if, in fact, the facts or the allegations come from information that is easily obtainable and available in publicly disclosed documents or otherwise in the public record. False Claims Act relators can be barred by the first to file bar, so they can't just come in with, oh yeah, I read this when somebody else pled it, and now I'm here to assert the same thing. A rare but certainly useful tool on the defense side is fee shifting. As many who are attending may know, a successful relator or litigant, false whistleblower litigant, is, when successful, is going to get his or her attorney's fees and costs paid for as part of a judgment or settlement down the road. But there is an avenue for fee shifting to the defense. It is a far more narrow avenue, but it's there. And in essence, when the case is brought frivolously or vexatiously or for the sole purpose of harassment, then a defendant may successfully have the opportunity to seek its own fees from the relator. DOJ always has the opportunity to dismiss. This was another one that was recently litigated and resolved at the United States Supreme Court. You know, when does the DOJ have the opportunity to come in and move to dismiss if that wasn't done at the outset and the DOJ didn't even intervene? And that was an interesting decision. And Jonathan, I think you may have something you want to add to that. So before I turn the floor over to you, let me just get to the last line on the slide, which is an often unrecognized restraint on whistleblowers, is that these cases take a long time to litigate and resolve, typically, not always, but typically. And so any whistleblower and his or her counsel is often going to be driven off merely by the amount of time, the expense, the commitment, the risk It's a lot to take this on, particularly if the DOJ has not intervened. It's a lot to take this on and stick with it for the period of time it often takes to resolve. So with that, Jonathan, I know you have something to add on the DOJ midstream dismissal point and perhaps anything else.
Yeah, the big thing, Jody, that I think whistleblowers or would-be whistleblowers think about is, at the end of this, there's going to be a federal case where you're accusing someone of committing fraud. And when I was at DOJ, I talked with a lot of whistleblowers. I talked with a few people who came forward with information who didn't want to file a key tam, but they wanted to alert the government to something they thought was fraudulent. And they've got there's a lot of concerns on their end. Some of the best whistleblowers I can remember during my time at DOJ were employees who had raised their concerns within. They were told they were wrong or they should just go away, and ended up deciding to file a key tam, knowing that was going to have a lot of consequence on their career. And so that's a really tough thing that relators have to think about. Is never mind that your current company or anything like that, if you're known as a whistleblower, what's the rest of the industry going to do? And they have very real concerns over that. And that was the thing that I remember from my time at DOJ, is that a lot of these whistleblowers really were coming forward knowing that there was going to be consequence, and that's it's unfortunate that there's consequence, but it sort of is what it is. The big thing is, the big constraint on whistleblowers here from a lawyer's side is that there could be a bigger constraint coming, which is the potential for key tams to no longer be seen as constitutional. So in the Polanski decision, Justice Thomas offered as an aside, just a note saying, hey, by the way, I don't think that this concept, that this key tam provision where the government is allowing a private citizen to stand in the shoes of the government, I don't think that's necessarily constitutional. And a bunch of litigants ever since then have been raising that when given the opportunity. There's a case in Florida right now, Zifferan or something like that, where this has been fully briefed. The U.S. Chamber of Commerce has come in and filed a statement saying whether the key tam provision should be allowed. The whistleblower bar has done the same. And so it's really interesting. They've got a judge there who may be prone to wanting to follow Justice Thomas. And so at some point, this is going to be litigated in the appellate level. It's not going to be anytime soon. I was telling someone yesterday, I don't think this is going to be, key tams won't be going away tomorrow or later this year, or probably even next year. And if they go away at all, I think this is a long time horizon. But I do get a lot of questions saying, hey, is this really a thing that's going to happen? So, that's the ultimate constraint on whistleblowers, is the Supreme Court at some point potentially saying that it's not a constitutional concept.
Yeah, that will be a very interesting one to watch. And I do agree with you. I think it'll take a while for that to percolate, but we are ear to the ground, seeing briefs that are filed that address that, and whispers about, ultimately where that might be first adjudicated and begin the long process of percolating up. So we're going to move on now to start talking about mechanics. How does all this work? Some of this may be well known to some of you who are attending, and some of you may not know this. So apologies if this is pretty obvious, but I think it's a good idea just to walk through what happens here and how does this process unfold itself. So a whistleblower and his or her attorney, or in the case of an entity, its attorney, will file the key tam lawsuit under seal. And the seal is a court order and cannot be violated and must not be violated. It is very serious to be in contempt of court by violating the seal on a currently sealed key tam lawsuit. Eventually it will be unsealed and become public record, but not in these initial stages. These initial stages can take a very long time, and so it can be challenging to maintain the seal and the secrecy, but it's critical. In any event, the relator and counsel will then serve the Department of Justice with a copy of the sealed qui tam lawsuit, along with a lengthy and very detailed disclosure of information that undergirds the allegations being made in the lawsuit. The DOJ then has the opportunity to investigate. The purpose of the DOJ's investigation is to determine whether to intervene in the lawsuit, and if so, or perhaps even if not, what to do about it. Try to get it settled, or any other options that are available to the DOJ. The investigation process takes some time, but typically involves the issuance of CIDs. And CIDs can seek all manner of discovery information from the putative defendant: interrogatories, depositions, document productions, all kinds of information. And that can take a while, because particularly document productions can be pretty intensive, pretty work intensive, and involve a lot of documents. So the DOJ will most often seek an extension of the intervention deadline. And Jonathan, you can speak to this, but I think you do have to report to the court, at least in writing, and seek the intervention and explain why the intervention is being sought. It doesn't go on forever and ever. You do have a judge who's looking and breathing down your neck and trying to figure out, when are you going to make a decision on intervention and get this thing moving. So I'll let you speak to that. But at the end of the process, the DOJ has a number of options. They're listed here: settle, intervene, decline, dismiss. And then after the DOJ makes its decision, the lawsuit is then unsealed and becomes part of the public record. So, Jonathan, if you want to round that out and then take us forward, feel free.
Yeah. What's interesting is, by statute, the Justice Department has 60 days to make an intervention decision. They can apply for extensions, as Jody said. How in the world Congress expected the Justice Department to make a decision to run a fraud investigation and make a decision on intervening within 60 days is beyond me. I'd love to talk to some members of Congress who think that's the timeline that federal investigations take. Crazy talk. I don't think anyone's ever done that, ever. Some districts have dollar amount thresholds, and they will just decline if you're under their threshold, just as a matter of course. But even then, like, you've still got to, the time that it takes for civil frauds to receive a complaint, process it, assign AUSAs, or in their case, trial attorneys, is a month. And so, the fact that the courts are expecting a 60-day intervention, or Congress is kind of funny. I've seen some really, really old qui tams. I'm thinking of one in the Northern District of Georgia, where Judge Totenberg dropped a famous footnote, blasting everyone for the fact that it had taken, I think, 14 years to get to her desk. Other judges elsewhere have a very tight window where they give you a year, and then after that, the DOJ is declining or not. That actually sometimes has a pretty bad result in that DOJ is making decisions with less than the full information. So, it goes both ways. But what happens when DOJ declines is that the whistleblower stands in the shoes of the government. We're going to talk in about maybe 10, 15, 20 minutes about exactly how this works. But the thing for you to know is, for those who are under federal investigation, if you think that there's a whistleblower who has initiated the investigation, just getting the DOJ to go away is good, always good, but that's not the end of it. You can oftentimes the whistleblower will continue on with the case if they feel strongly about the case. They'll continue to litigate it as though they are the government, and they'll stand in the shoes of the government, and they'll continue to move the case forward. They'll put on evidence. And that's a really interesting situation where the government is not participating in the litigation fully as a full participant, but they remain the party of interest in interest. So that's a really interesting situation that we'll talk about a little more in a few minutes. But this slide that's on your screen now is one that's really interesting to me. These numbers vary a lot, but I think this shows exactly what whistleblowers' role is in litigation, and it's largely that they're driving DOJ's enforcement priorities. You know, DOJ. If you hear DOJ leadership talk about what their priorities are, they talk about this or that. Here are the things that we're going to do, you know, these next few years. But in reality, these numbers show that that largely the whistleblower bar is driving DOJ's priorities when it comes to the False Claims Act. And so the 89% from 2022, that's in dollars, and that's in both declined qui temps and intervened qui temps. But that 11% are those are just cases where DOJ found the case without any sort of whistleblower involvement. That's really, really interesting to me, showing like the exact role of whistleblowers. They have a really big impact on what DOJ is investigating. Now, DOJ is getting really, really good with data analytics. I know they are from a healthcare fraud perspective and from, you know, COVID fraud issues. They're getting really, really good, but still whistleblowers are driving a lot of the boat here when it comes to these cases. Jody, did you want to say anything else about whistleblowers' role, or should we jump into incentives?
Let's jump into incentives. So you may be asking yourself why. What is incentivizing whistleblowers to do this, especially given what we were saying before about the magnitude of time, risk, expense, you know, personal, you know, the sort of personal aspect of going through something like this? Well, there are any number of reasons why whistleblowers may be incentivized to do this, to participate in this process. And of course they range. The first, I think, thing to recognize is that damages and penalties under the False Claims Act are extremely significant from a monetary standpoint. Even relatively small exposure in the FCA space is large exposure just in terms of dollars. And so knowing that, Jonathan, why would a whistleblower want to do this?
Yeah, look, money's the primary reason. You know, there are a lot, like I said earlier, there are a lot who come in with information and they don't file qui temps, and those are fantastic people. But, you know, there's a reason that Congress created the False Claims Act statute to reward whistleblowers. It's because whistleblowers have unique information that Congress said, we want to encourage them to come forward, file these qui temps, and stop, you know, wrongs that are being done. And so Congress said, all right, well, let's give relators, not realtors, let's give relators a portion of the recovery. So the share that relators get if the government takes the case is 15 to 25%. Now that can be tweaked some downward if the person who's bringing the case was like a part of the scheme. That's discouraged. Is doing the crime and then saying, hey, I did this crime. But that 15 to 25% can be a lot of money. That adds up really quickly when some of these cases are talking about hundreds of millions of dollars. If the Justice Department does not take the case, if they decline to intervene, but the relator wants to take the case forward anyway, you're then looking at 25 to 30% of the total recovery. And that's not all. You also get your attorney's fees and costs. That can be a lot of money. There are a lot of really excellent whistleblower attorneys out there who put a lot of thought into their cases. They do a lot of legal research on the front end. They think about how to frame these cases when they're pitching them to the Justice Department in a way that can show the value that this case has relative to other ways that DOJ attorneys can spend their time. The big thing that DOJ attorney that you want when you're a whistleblower attorney, big thing you want is you want your DOJ attorneys to spend time on this. So you want to pitch this in a way where they're going to get invested, where they're going to say, this matters to me. I'm going to go take 47 CIDs and spend a lot of time on this. those attorney's fees, the reason you do that is because you want the DOJ to like your case. You want them to be driving the boat when it comes to settlement. But then you get your attorney's fees on the back end. And so I have a lot of clients who they will be working with the government, and then all of a sudden I'm reminding them the whole time, hey, there's the possibility here that this is a key tam. We could owe some attorney's fees on the back end. And then you start talking turkey with the government, and then you find out, well, there's this relator, and they're asking for $12 million in attorney's fees. That's, there are always negotiations on that, but by statute, whistleblowers are entitled to recover their reasonable attorney's fees and costs that way. The retaliation claim is another interesting part. When you're dealing with a person who is a former employee, and a lot of very good whistleblowers are former employees, the False Claims Act allows them to file an additional count, which is called a retaliation claim. So if someone engages in protected activity and then they have a negative consequence for it, they can recover under a retaliation theory against that person as well. It's usually included in the key tam, and it's sort of negotiated separately. We're going to talk in a little bit about how that makes some interesting dynamics when you come to settlement. But there's look, I've dealt with a lot of whistleblowers, and dollars is certainly a sense. A lot of them are coming forward for the right reason. So not all of them, but a lot of them are coming forward because they genuinely dislike people who are defrauding the government. I'm a taxpayer, as many of you who are listening are, and I don't like fraud against the government. I want the people doing business with the government to not be ripping them off. We can disagree as to what's something that is fraud and what's something that's sort of a mere regulatory mishap. But in general, a lot of whistleblowers come forward because they want to be doing their civic duty and ferreting out fraud when they think something bad's happening. Jody, do you think we're missing anything here?
I don't. I think that kind of runs the gamut. So we'll move from here into practical considerations, just some things to be thinking about if you are going through this process of an investigation, or even into litigation. And I mentioned before the seal. So of course, if you're on the defense side of this, you shouldn't know about a sealed key tam while it is still under seal. If the seal is violated, that's an important moment, and that ought to be noted and discussed and redressed. But you may be asking, well, how would I know that there's a sealed key tam? And Jonathan, it's certainly true that you will not get notice of a key tam while it is a sealed key tam. However, during the government's investigation, there are some telltale signs that there's probably or maybe a key tam that's on file. Of course, we ought to note that the government can initiate its own False Claims Act investigation, right? And we saw that in the pie, chart a little bit earlier, somewhere around 11% are DOJ initiated False Claims Act cases. So it is not true that every CID that gets issued necessarily correlates to the existence of a relator and relators counsel. But the existence of a CID and that process certainly does correlate to a False Claims Act investigation, and that often springboards into some guessing or discussion or wondering if there is indeed a relator out there who's filed a sealed key tam lawsuit. Jonathan, I know that you and I have talked a lot about whistleblowers with documents and recordings, and about the DOJ giving documents to a whistleblower. So let me let you take on those two.
Yeah, one of the interesting things that some of my clients ask about is, well, they're used to being sued, and they're used to getting a copy of the complaint, and so it sort of drives them crazy to know there could be a complaint out there in federal court that I have no knowledge of, or there could not be. What's interesting, so the mechanics of that, I remember several cases where there was a key tam filed. I was handling it for DOJ, and we thought it was a bad key tam, and we went to the Relators Council and said, look, we're declining, and here's something that you may want to think about when it comes to this in terms of you proving your case. And they would say, yeah, good point. Let's not spend any more time on this. And we would then send out letters to all the named defendants. In some key tams, there are 50 named defendants, as one of mine was. And then you get calls from people saying, what is this? How do I clear my name? And I said, you don't have to respond to it. This is just your notice that you were named in a key tam, and it's not going anywhere. But you'd be amazed how many corporate people who have been named in key tam but never are investigated, as several of mine were. They get this notice and they want to defend themselves, but there's no platform for doing it because the case is closed. Another thing that clients ask me about is, because there are some horror stories out there of whistleblowers who are current employees remaining at work and taking documents out with them, making recordings of meetings. And that's a really interesting case. Jody, when we were doing the podcast, we talked about, I think his name was Dr. Akula in New Orleans, who was convicted of healthcare fraud last year. And we talked about how that case started with a key tam. That case started with a key tam that was filed by a current employee. And that current employee was making recorded phone calls during the workday, walking out with documents and giving them to the FBI. That sort of thing. So I get clients who, since we dropped that podcast, ask, is that something that we should be worried about? And my answer to them is, it's possible. I don't think that was all that likely when I actually don't know that I saw many current employees ever file a key tam when I was at DOJ. I think it's a rare thing, but even if you do have a current employee who is who has named you in a key tam, it's a terrible idea to retaliate against them. I just don't think there's anything that you can do where you shouldn't implement new policies in order to ferret out a key tam. We talked about retaliation a little while ago. That's the consequence. If you start all of a sudden not trusting your people, you're going to have really bad problems from business reasons and not just retaliation, legal issues. And so if you think that you have someone who is a current employee, yes, they could record conversations. But if you're having conversations that you're, super afraid of having anyway, we should talk about how to resolve your case, because you're probably doing something wrong anyway. And so that's my normal response there is, tell me about these meetings that you're having that you don't want to have recorded, because whistleblowers can record things, and you should be careful not to retaliate against them. Jody, you also asked what happens when can the Justice Department give CID returns to whistleblowers? And the answer to that surprises a lot of people. So the answer to that is actually yes. It certainly happens. I don't think that it's allowed to happen under the text of the False Claims Act, but it does happen. And there was a recent case that sort of talked about the disaster here when it comes to this. There's a case in Boston called MD Spine, where the U.S. Attorney's Office in Boston was investigating MD Spine, and MD Spine, for some reason, turned over attorney-client privilege documents inadvertently. And in the course of this, they turned over attorney-client privileged documents, and the Justice Department was giving those to the whistleblowers. So at some point, the Justice Department declines to intervene, and the whistleblowers take this and I think they amend their complaint and include a bunch of attorney-client privileged information. And MD Spine says, whoa. What? You shouldn't have these documents. We gave them as part of our CID process. And that's attorney-client privileged. And the court there ruled that they because they didn't take the right precautions in avoiding the dissemination of attorney-client privileged information, and that they didn't act fast enough to claw these documents back. And so they had waived the privilege, and it was proper for the relator to have them. I think that's a disastrous result. This is why, for the clients on the call, there's a reason we look at your documents before we give them to the Justice Department. That case is one of the reasons. because it's disaster if the whistleblower gets his or her hands on attorney-client privileged information. It's really, 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 really bad. So that's why we look at those. Since that case, I've started including, Jody, extra language saying, by the way, here's our read of the False Claims Act, that False Claims Act investigators are the ones who are supposed to have these documents. And if you're not within that custodian group, and that to me does not include whistleblowers, then you're not supposed to have this. And so give me this over. And I haven't had a DOJ attorney balk at that since then. But I think that's an interesting issue. Apparently, this is happening more than we think it is. Jody, do you have anything else to add when it comes to DOJ giving documents to whistleblowers?
I mean, I don't have anything else to add other than, that whole story is worthy of a significant grimace and, a lot of need to make sure at the outset that documents that are being turned over are indeed, carefully reviewed, and there are ways to claw back an inadvertent production of privileged items, and that should be done. The vigilance of the process, even in these early stages, I don't think can be overstated. It's just very important to make sure that these productions and CID responses and so on are handled so carefully from the beginning. But it does remind me of wanting to make two additional points. The first is we've talked a lot about retaliation and the anti-retaliation provisions of the False Claims Act, and I think it's natural and normal for a defendant, who is responding to CIDs and is aware that there's an investigation and thinks they're later out there. It's natural to sort of be wondering, who is it, and who do we need to be careful of, and are we in meetings with somebody who's recording it or taking documents? And I just would suggest that natural inclination, while understandable, is not well followed up on. In other words, you just have to take that curiosity and try to put it to bed, because it's very counterproductive to try to ferret out who is the relator, because it leads to conduct that could be deemed retaliatory, and then we're off in a whole different direction, dealing with allegations of retaliation and retaliatory activities. It sounds, I think, trite, but I'll go ahead and just say, the best defense to any of this is a good offense, meaning a very healthy compliance program and very healthy prospective protections that are in place to ensure that, reporting is done up the chain and taken very seriously if somebody has concerns about alleged, false claims submitted to a government payer. But the other point I wanted to make, and it's just sort of been gently alluded to a couple of times in our discussions here, is the point about the differentiation between the False Claims Act as a civil statute with civil remedies in civil litigation versus the criminal justice system. Because these are not crimes that are being alleged under the False Claims Act. These are civil violations, but very often, False Claims Act investigations will run parallel to criminal investigations, and neither remedy is exclusive of the other. There are some interesting nuances that sort of dovetail in the kind of the interstitial relationship between the criminal justice system and the False Claims Act system. I think it's important to lay eyes on the possibility that there may be a parallel criminal investigation running in the background, because sometimes that can impact, for example, interrogatory responses or deposition testimony and so on. So, we could do a whole webinar on that. I don't want to get too far in the weeds on that, but it's a very good idea. often in the healthcare space, but not exclusively in the healthcare space, to make sure that there's at least some consideration being given to, might there be a parallel criminal investigation going on in the background here? And Jonathan, I just wanted to add those 2 points, but is there anything about any of that that you want to put a sort of finishing touch on?
No, I think that makes a lot of sense, and that's also probably the reason why this string of cases in the Northern District of Mississippi, where they're bringing hundreds of PPP-based False Claims Act complaints, it's probably why you don't see a lot of people contesting those, is because they know, I don't want to make any statements. I don't want to. I'll take the judgment against me, but let's see what the asset recovery unit can get from me in post judgment proceedings. But I'm not gonna touch any part of that. I think that's probably why, because you've got to be on guard against the potential for there being criminal liability for whatever is being investigated as well. And if there's if a CID is served, that doesn't mean it's inherently that it's just civil. There are examples of CIDs being served where there's a criminal file as well. I had one of those where we had a strategic reason for the civil AUSA in that case serving as CID, but then very quickly we told them, by the way, this is fundamentally a criminal case, and I am here, and we had that conversation. But not all AUSAs are going to tell you that. That's why you got to ask the question. One of the things, Jody, that I hear a lot from clients is, what do I do if I'm wrongfully accused in this? How do I clear my name? Here's the unfortunate part of this, is that there is not a very good vehicle for people to sort of get back to punish the relator if the relator is bringing something that's wrongfully accused. The False Claims Act lays out exactly the case where you can recover against the relator for wrongful accusations, and it's got to rise to a pretty high level. The level it's got to rise to is acts that are clearly frivolous, clearly vexatious, or brought primarily for the purpose of harassment. Courts in general are going to stick with that. There have been a handful of cases recently where courts have entertained, claims that key tams were brought inappropriately. There's a case in March, the jail case, JEHL, where the relator was ordered to pay, I think, $1 million, close to $1 million in attorney